This is LXBN TV, and I'm Colin O'Keefe. The FTC recently issued a set of proposed rules regarding the implementation of the Children's Online Privacy Protection Act. Joining me now to explain those rules and industry concerns surrounding them, we bring in Eric Bukstein of Hogan Lovells and their blog, Chronicle of Data Protection. Eric, first off, can you give some background on exactly what COPPA is and how it came into existence?
Sure, Colin, my pleasure. The Children's Online Privacy Protection Act, or COPPA, was a law that was enacted in 1998. The intent of the law is to protect young children online and to give parents of young children control over what information is being collected about their children online. And the law gives the Federal Trade Commission, or the FTC, both rulemaking and enforcement authority. And in 1999, the FTC used that rulemaking authority to issue the current COPPA rules. And these rules detail exactly what companies need to do in order to comply with COPPA. Both the law and the regulation became effective in 2000. Now, briefly, COPPA regulates both websites and online services that are either directed at children under the age of 13 or that if they're not specifically directed at children under the age of 13, websites that have knowledge that they're actually collecting information from children under the age of 13. Typically, COPPA is not enforceable against websites or online services that are not operated for commercial purposes, so nonprofit websites and websites of those natures. Very, very quickly, basic COPPA requirements include posting a privacy policy, providing direct notice to a parent of a child under 13, and obtaining verifiable parental consent using certain listed or types of mechanisms that the FTC has provided, and also giving the parents certain choices about the collection and use of the child's information. Also providing parents access to their child's personal information, if personal information is collected, in order to review that information, and if they'd like to have that information deleted. And finally, the COPPA rules detail maintenance of the confidentiality, security, integrity of information collected from children.
I see. And then what do you see as the biggest proposed changes the FTC is making to COPPA?
Just to backtrack, so last September there was proposed rules, and then just last week the FTC issued a supplemental proposal which sought to clarify some of these issues. Some of the issues, raised by the proposed rules based on the comments that they had gotten back from industry and privacy advocates and others based on those rules. And it's important to point out that these rules at this point are just proposed, and the changes will not be final until the FTC responds to all these comments, issues final rules, and that'll likely happen in the fall or winter, and then we'll have a much better sense of exactly what companies will be required to do. Now, the most recent supplemental proposals, these are the ones that were issued just last week, propose a number of clarifications and changes to those proposed changes from last September. First, the FTC clarified that the definition of operator, so this is an operator of a website or an online service, would include website plugins, including social networking plugins and ad networks, and also websites and online services that use them. So if you're a children's website and you use a social network type plugin, for example, the Facebook like functionality, you would, based on this proposal, be swept into the rule. Also, certain kinds of ad networks would also be swept into this definition. So if you're a website that is directed towards 12-year-old children or younger children, and you use an ad network that collects personal information, including like I said, IP address, you would also be subject to the rule. Another change in the most recent proposal was extending the definition of personal information. They modified this definition in two ways. First is to make of persistent identifiers within personal information, so that's your IP addresses and other information like that, would not be considered personal information if it's used for a website or service provider's internal operations or to support those internal operations. And the FTC includes the definition for support for internal operations. So this carves out certain types of uses from that definition of personal information. The FTC also proposed to change the definition of personal information to clarify that screen names, which would otherwise be considered personal information, would not be considered personal information if those screen names do not rise to the level of an identifier. So in other words, if you have a screen name that's not your email address or your instant messenger profile name, it would be okay. And this is really a nod towards industry, as many websites attempt not to collect personal information, but still allow people to log in and have certain functionality by, instead of having personal information collected, they collect a username, which cannot include personal information. The final change that the FTC proposed in the most recent supplemental proposal was clarifying the definition of website or online service directed to children, to clarify that it applies not only to a website that's only appealing or directed towards children under 13, but also to websites that have a broader audience that would include children. This codifies what's currently a concept in the COPPA rule, that a website that appeals to a broad range of individuals, including children, for example, a website promoting a Disney film that would appeal to both children and also their parents who might want to take them to the film. It clarifies that these types of websites must age screen users and either apply COPPA users or COPPA protections to users that are under the age of 13, or not allow those users to enter any personal information.
I see. And then finally, what concerns and potential comments do you envision members of the industry to have in response to these proposed rules?
These proposed regulations continue on the trend of the proposed September changes of expanding the scope of COPPA and also the scope of entities that would be covered by COPPA. The requirement that entities, third parties that offer plugins on websites directed toward children comply with COPPA would extend the scope of COPPA significantly. The FTC proposes to put a joint burden on both that third-party service provider, the social networking site or the ad network, and the operator of the children's website to make sure that there's COPPA compliance. That proposed clarifications and the questions involving how exactly do those entities cooperate are certain to raise significant questions. Also, the proposed changes to the definition of personal information, where persistent identifiers are considered personal information unless they are considered to be for the support of internal operations for a website, will also garner significant industry attention. There's a big gray area as to what would be considered support for internal operations. With a narrow reading of the proposed rule, even with a narrow reading, you would have a situation where a lot of activity that was not previously thought to have been covered by COPPA will be brought into the COPPA regulatory framework. This is where, for example, you have an ad network that operates on multiple sites, but it's used by a particular operator of a website that's geared towards children for a contextual ad delivery on that site. Now, I'm not talking about any sort of behavioral tracking between or across multiple sites, but it's really just used on that one site. But yet the cookie that's used for that ad delivery is also used on other sites. And it's unclear, would that count or would that be okay as support for internal operations? And the final change that I think will be significant and garner some comments is the idea that websites that are likely to attract a disproportionately large percentage of children under the age of 13. So a website that is really for a general audience but does have a significant population of children that are interested would have to implement certain protections for those users under 13. This will likely lead to a lot of websites that don't currently have age screening mechanisms to have to implement those age screening mechanisms and apply certain protections accordingly. I think industry will certainly be interested in pushing on the contours of that to understand when exactly will age screening mechanisms be necessary, what will those mechanisms look like, and how can they make sure that they're compliant after they've implemented that, either by making it so that children under 13 cannot participate on the website, or applying protections, but only to the subset of users that are under 13. I think all in all, the changes to the proposed changes to the COPPA rule would significantly impact almost any company that operates websites or online services such as mobile apps that are attractive to children under the age of 13. And those companies should consider these proposals and consider submitting comments to the Federal Trade Commission. And in any case, the company should make sure that they understand the final rule when it comes out and what implications it'll have on their websites, on their online services, so they can make appropriate adjustments.
Very interesting. Yeah, of course, privacy is always a huge concern, and as technology continues to change, those rules are going to have to change, especially with regard to children, where it's an almost more serious issue than it is other places. Well, once again, that was Eric Bukstein of Hogan Lovells and the Chronicle of Data Protection. For more of his commentary, be sure to visit hldataprotection.com, and for more LXBN TV interviews, visit lxbn.lexblog.com. Thanks, Eric.
Thanks, Colin.